Welcome to the 42nd video in our weekly legal update series. In this video, we will be discussing news items from 6 September to 11 September 2021. In first important news, the Supreme Court has held that arbitral award cannot be set aside on contravention of laws which are not related to public policy or public interest. In the case of Delhi Airport Metro Express Limited versus DMRC, the court has said that contravention of a statute which is not linked to public interest or public policy cannot be grounds to set aside an arbitral award. The court has also noted that there has been a disturbing tendency of courts setting aside arbitral awards. Court has further noted that every error of law committed by the arbitral tribunal would not fall within patent illegality. In second important news, the Supreme Court has clarified the importance of mutation entry. In the case of Jitendra Singh versus State of Madhya Pradesh, the Supreme Court has noted that a mutation entry in the revenue record is only for fiscal purposes and does not confer any right, title, or interest in favor of any person. The court has noted that entries in the revenue records or Jambandi have only fiscal purpose, that is payment of land revenue, and no ownership is conferred on the basis of such entries. It is further observed that so far as the title of the property is concerned, it can only be decided by a competent civil court. In third important news, the Supreme Court has held that in case of violation of retrenchment conditions under Section 25F of the Industrial Disputes Act, reinstatement of terminated workmen is not automatic. In the case of Ranbir Singh versus Executive Engineer PWD, court has noted that reinstatement cannot be automatic and the transgression of Section 25F being established, suitable compensation would be the appropriate remedy. In fourth important news, the Supreme Court has held that law not to be construed retrospectively unless there is a clear or manifest intention to the contrary. In the case of Assistant Excise Commissioner versus Sthapan Cherian, court has noted that in the absence of express statutory authorization, rules or regulations cannot operate retrospectively. Court has said that there is profusion of judicial authority on the proposition that a rule or law cannot be construed as retrospective unless it expresses a clear or manifest intention to the contrary. Another equally important principle applies that in the absence of express statutory authorization, delegated legislation in the form of rules or regulations cannot operate retrospectively. In fifth important news, Supreme Court has held that no negligence attributable to medical professionals merely because the treatment is not successful. In the case of Dr. Harish Kumar Khurana versus Joginder Singh, court has noted that in every case where the treatment is not successful or the patient dies during surgery, it cannot be automatically assumed that the medical professional was negligent. To indicate negligence, there should be material available on record or else appropriate medical evidence should be tendered. In sixth important news, court has noted that adjudicatory function of NGT cannot be assigned to committees. In the case of Sangar Zubair Ismail versus Ministry of Environment, court has noted that constitution of an expert committee does not absolve the National Green Tribunal of its duty to adjudicate. The adjudicatory function of NGT cannot be assigned to committees, even expert committees. The decision has to be that of the NGT, as the NGT has been constituted as an expert adjudicatory authority under an act of the Parliament. Lastly, the Supreme Court has clarified that the presiding deity and not the pujari is the owner of the land attached to the temple. In the case of State of Madhya Pradesh versus Pujari Utthan Evam Kalyan Samiti case, Supreme Court has upheld the MP government circulars to delete the names of pujaris from revenue records pertaining to temple properties. The court has also noted that the law is clear on the distinction that the pujari is not a Kashtkar Murushi, that is a tenant in cultivation or a government lessee or an ordinary tenant of the land, but only holds such land on behalf of the Awqaf department. The court has also noted that the pujari is only a grantee to manage the property of the deity, and such grant can be reassumed if the pujari fails to do the task assigned to him. That is, to offer prayers and manage the land. He cannot be thus treated as a Bhumi Swami. This brings us to the end of our weekly news. If you like our content, please like and share this video and subscribe to our YouTube channel.